Hello, we are Group 2 and we are about to present the case of Fidela del Castillo, VDA, de Mistica versus Bernardino Naguiat and Maria Paulina GERONA-NAGUIAT, General Register Number 137909.
Eulalia Mistica is the owner of a parcel of land located at Malhacan, May Kawayan, Bulacan. On April 5, 1979, Eulalia Mistica and Maria Paulina Naguyat made a contract stating that a 200 square meter of Mistica's land was sold to Naguyat for 20,000 pesos. The contract stated that it is na ang nagbibili ay nagmamay-aring tunay at naghahawak ng isang lagay na lupa na nasa nayon ng Malhacan, bayan ng May Kawayan, lalawigan ng Bulacan, na ang kabuuan sukat at mga kahanggan nito gaya ng sumusunod. Naalang-alang sa halagang 20,000 piso, kwaltang Pilipino. Ang nagbibili ay nakipagkasundo ng kanyang ipagbibili ang isang bahagi o sukat na 200 metros parisukat. Sa lupang nabanggit sa itaas na ang mga kahanggan nito ay gaya ng sumusunod.
Na magbibigay ng paunang bayad ang bumibili sa nagbibili na halagang 2,000 piso kaultang Pilipino sa sandaling nagdaan ito ng kasulatan. Na ang natitirang halagang 18,000 piso kaultang Pilipino ay babayaran ng bumibili sa loob ng 10 taon na magsisimula sa araw din ng lagdaan ang kasulatang ito.
Sakaling hindi makakabayad ang bumili sa loob ng panahon, pinagkasunduan ang bumili ay magbabayad ng pakinabang o interes ng 12% isang taon sa taon nilakaran hanggang sa ito'y mababayaran tuluyan ng bumibili. Sa katunayan ng lahat ay nilagdaan ng magkabilang panig ang kasulatan ito. Ngayong 5 ng Abril 1979, sa bayan ng May Kawayan, lalawigan ng Bulacan, Pilipinas.
The respondent made a down payment of 2,000 pesos in accordance with their contract. He failed to make any payments thereafter. On December 4, 1991, the petitioner filed a complaint for rescission alleging inter alia to the failure and refusal of respondents to pay the balance of the purchase price constitutes a violation of the contract which entitles her to resign the same. That the respondents have been in possession of the subject portion and they should be ordered to vacate and surrender possession of the same to the petitioner. That the reasonable amount of rental for the subject land is 200 pesos a month. That on the account of unjustified accusation of respondents, the petitioner has been constrained to legislate where she incurred expenses for attorney's fees and litigation expenses in the sum of 20,000 pesos.
Ang kontrata ay hindi maaaring ipagsawalang bahala dahil malinaw na nakasaad dito na kapag nagkaroon ng kabiguang bayaran sa aming parte sa itinakdang usapan, ay maaari pa rin kaming magbayad na may patok na taunang interes na 12% hanggang sa tuluyan naming mabayaran ang kabuuan. Sa katunayan, noong October 1986, sa kalagayan ng yumaong asawa niya na si Eulalia Mistica, ay inalok namin siyang bayaran ang natitira pa naming balanse sa kanila. Ngunit ito ay tumanggi.
On July 8, 1992, the respondent also filed a motion to dismiss, which was denied by the court on July 29, 1992. The motion for reconsideration was likewise denied for its order of March 17, 1993. After the presentation of evidence, the court on January 27, 1995 rendered the now assailed judgment.
Wherefore, premises considered, judgment is hereby rendered, dismissing the complaint and ordering the petitioner to pay the respondents attorney's fee in the amount of 10,000 and cost of the suit, ordering the respondents CA to pay the petitioner and the heirs of Eulalia Mystica the balance of the purchase price in the amount of 17,000 with interest thereon at the rate of 12% per annum computed from April 5, 1989 until full payment is made, subject to the application of the consigned amount to such payment. B. To return to the petitioner and the heirs of Eulalia Mystica the extra area of 58 square meters from the land covered by OCP number 4917. The corresponding price, therefore, based on the prevailing market price thereof.
According to the Court of Appeals decision, they disallowed rescission. The CA held that the respondents did not breach the contract of sale. It explained that the conclusion of the 10-year period was not a resolutory term, because the contract had stipulated that payment with interest of 12%. It could still be made if respondents failed to pay within the period. According to the appellate court, the petitioner did not disprove the allegation of respondents that they had tendered payment of the balance of the purchase price during her husband's funeral, which was well within the 10-year period. Moreover, rescission would be unjust to respondents because they had already transferred the land title to their names. The proper resource, the CA held, was to order them to pay the balance of the purchase price with 12% interest. As to the matter of the extra 58 square meters, the CA held that its reconveyance was no longer feasible because it has been included in the title issued to them. The appellate court ruled that the only remedy available was to order them to pay the petitioner the fair market value of the unserved portion, hence this petition.
After they knew the decision of the Court of Appeal, petitioner raises the following issues in her memorandum. Whether or not the Honorable Court of Appeals erred in the application of Article 1191 of the New Civil Code as it ruled that there is no breach obligation in spite of the lapse of the stipulated period and the failure of the private respondents to pay. Whether or not the Honorable Court of Appeal erred in ruling the rescission of the contract is no longer feasible considering that a certificate of title had been issued in favor of private respondents. Whether or not the Honorable Court of Appeals erred in ruling that since the 58 square meter portion in question is covered by a certificate of title in the names of a private respondents, reconveyance is no longer feasible and proper. After the petitioner raised the following issues and passed the memorandum to the court, thereof the official ruling of the court was,
The petition is without merit.
this means that the petitioner's judicial findings have no legal or factual basis to strengthen their legal argument. In support of the CA, here are some relevant facts and findings of the court about this case.
Based on the kasulatan that Eulalia Mystica and respondents agreed upon, CA clearly stated that it was a contract of sale, in which the failure of respondents to address the balance of the purchase price inside 10 years from the execution of the deed didn't add up to the substantial breach. B. The CA prohibited the rescission because it is written in the deed that the payment is dependent if the respondent wants to pay. Since there is already a partial payment given by Naguiat, it proves that they are willing to do their obligation written in the contract. C. The complaint of rescission filed by the petitioner was denied by the court because the land title was already given to Bernardino Naguiat. The CA then ordered the respondent to pay the remaining balance of the purchase price plus the 12% interest. So ordered.
Hi, this is Mary Monica Conchada as the narrator.
Hi, my name's Sophia Luis Hebron, also as the narrator.
Hi, I'm Mika Perol. I'm Maria Paulina Nagit.
Hi, I'm John Austin C. Plata. I'm Eugelio Mistica.
Hi, I'm Donna Bianca Ligutan as the judge. Thank you.
Thank
Thank
you.
you.